Well, everybody, good morning and welcome to the March edition of our Brunch series. These 3PB webinars are an opportunity to tune into Zoom, sit back with a warm beverage and brush up on some contemporary legal topics. And I'm confident the subject of today's talk is particularly contemporary because as we know, the basis for obtaining a divorce in England and Wales is about to undergo fundamental change on the 6th of April. Can I introduce myself? My name is Hamish Dunlop. I'm head of finance of 3PB Family Group. I specialise in divorce and matrimonial finance. And in my talk, Divorce in the Modern Age, we're going to be looking at changes brought about or to be brought about by the 2020 Divorce, Dissolution and Separation Act. I'm going to use slides during the talk. Those slides and an additional text handout are also available afterwards, so that those will be handed out, I hope, at some stage today or tomorrow. I'm very pleased to welcome also to the webinar Poonam Bhari, a popular member of the 3PB family team, described by the Legal 500 as a superb advocate. But crucially for today, she is also a member of the FPR Rules Committee, the committee, of course, responsible for preparing the rule changes which are going to be ancillary to the new Act. And she's very kindly agreed to come along and talk about some of the changes that are going to happen in April and shed some, I hope, valuable light on the rationale behind them. And in particular, she's going to deal with the question of costs. Can I ask you throughout the talk to try and ensure your mute button is switched on? We're very happy to take questions. Please use the chat function at the bottom of the screen to communicate in text. We'll try and answer them at the end of the talk. If we don't get to them, please forgive us. We will, I promise, send out replies and probably publish the replies as well once the talk is said and done. And so to the talk. Well, our divorce system for a modern age has finally arrived. Mr. Justice Mumby, President, when beginning his judgment in the Court of Appeal in Owens, started with an eminently quotable remark, which I'm going to use perhaps to bring us into the zone for the talk. Parliament, he said, has decreed that it's not a ground for divorce, that quite simply you find yourself in a wretchedly unhappy marriage, though some people may say it should be. Well, on the 6th of April 2022, that's Wednesday fortnight, a new divorce regime, as we know, will be ushered in courtesy of the Divorce, Dissolution and Separation Act 2020. It will bring in a new Section 1 to the MCA of 1973. And coming with it will be associated amendments to the FPR, the Family Procedure Rules, and a new HMCTS online service for applying for a divorce. So much to look forward to in April. And we're going to be looking, of course, at all of those in this relatively short talk today. But before I turn to the new regime, I just wanted to put the new law into a little bit of historical context. The current regime, of course, that requires parties either to wait at least 2 years to bring a petition for divorce or alternatively to essentially blame the other party for the breakdown of the marriage. That regime's, as we recognise probably, over 50 years old. And it now seems to many contemporary ears and eyes to be somewhat anachronistic and oppressive. But the change we're about to see in April is, of course, simply the latest step in a journey that started as long ago as 1670, when the first man, and of course it was a man, Lord Roos, was permitted a divorce by private act of Parliament. Before 1670, even kings couldn't obtain a divorce. Henry VIII, of course, famously disposed of his wives, either when they died, two by royal command, we remember, or alternatively that the marriages he wanted to get out of, he simply caused to be annulled. And so if we return to 1670, for almost 200 years, divorces were only available by virtue of private act of Parliament, and also, of course, almost exclusively granted to rich men. It took till 1801 for the first woman to obtain a divorce by private act of Parliament. And then finally, in 1857, the courts were given the power to grant divorces to individuals. But to successfully apply for such a divorce, the petitioner had to, those of you may know, had to prove one of the matrimonial offences, adultery, cruelty, or desertion. And you might think that term matrimonial offence demonstrates the kind of moral culpability that was required in order to obtain a divorce. And that regime, with the highly culpable matrimonial offence, was only abolished in 1969, with what is now the current regime that we operate under, the precursor to the Matrimonial Causes Act, the Divorce Reform Act of '69. And at that stage, the new regime swept in. And so I suggest that as we bury the current regime at sundown on the 5th of April in 2 weeks' time, have a thought to the important place that it has served in the development of English divorces. I'm now going to share a few slides with you, so just bear with me as I put those up on the screen. Well, here is, of course, the existing regime. Section 1 of the Matrimonial Causes Act 73. Subsection 1 reminds us that the only ground for a divorce is that the marriage has broken down irretrievably. Subsection 2 presents a second hurdle that a petitioner to a divorce has to prove. They have to prove one of 5 facts. Those facts, of course, are all too familiar to us. Adultery, what is lazily called unreasonable behaviour, desertion, 2 years separation plus consent, or 5 years separation. And so the petitioner has to essentially prove 2 hurdles, subsection 1 and subsection 2. You may think it's a curiously worded provision, not least because the petitioner doesn't have to prove that one of the facts caused the irretrievable breakdown. Subsection 3 and 4 set up what at face value seems to be a fairly robust process that the court goes through to satisfy itself that those 2 hurdles have been surmounted. It'll be the duty of the court to inquire, says the section, into the facts alleged by the petitioner and into any facts alleged by the respondent. And only if the court is satisfied on the evidence of any fact, then unless it's satisfied on all the evidence the marriage has not broken down irretrievably, it shall grant a decree of divorce. Again, a curiously worded section where you may think the sort of burden shifts across the piece. But most importantly, for the purpose of this talk, it suggests, doesn't it, a sort of robust, independent judicial inquiry into the facts. Are the facts in the petition true? Are they robust enough to fulfill the fairly demanding statutory test? In reality, as we recognise, as did Sir James Mumby in Owens, a system of sort of intellectual dishonesty has developed. The Law Society's Family Law Protocol, the Resolution's Good Practice Guide to Correspondence, all of these encourage anodyne allegations in the petition and an anodyne approach to the correspondence, stripping out the heat from the marriage breakdown. And then, of course, when a judge reviews an undefended divorce under FPR 720, the special procedure, the judge simply has to ask, well, assuming the allegations in the petition are true, is this enough to amount to, particularly the behaviour petition, amount to behaviour as intended by the statute? And we recognise, I think, as modern divorce lawyers, that all of this is designed to try and bring the heat out of it. But in the faces we see of that rather robust test, there is a sort of departure of what's going on in the courts, a collusion between lawyers and judiciary as against the strict mandate of the Act. And of course, that is one illustration of how reform has been necessary. And reform we now have. On screen, we have the new Section 1 of the Matrimonial Causes Act 1973. The first point I make is a fairly binary one, which is that the new Divorce, Dissolution and Separation Act doesn't create a new regime on its own. It simply replaces Section 1 of the MCA. So the good news for us is that once, of course, the records are updated online and in hard copy, we will simply, as we ever did, go to Section 1 of the MCA 1973, and there in the great tome, we'll find at Section 1 the new regime for divorce. What does it say? Well, the new Section 1, subsection 1, reads like this. Subject to Section 3, either or both parties to a marriage may apply to the court for an order, a divorce order, which dissolves the marriage on the ground that the marriage has broken down irretrievably. An application under subsection 1 must be accompanied by a statement by the applicant or applicants that the marriage has broken down irretrievably. And the court dealing with an application under subsection 1 must take the statement to be conclusive evidence that the marriage has broken down irretrievably and make a divorce order. Well, we see that the irretrievable breakdown of a marriage remains the single ground on which a marriage can be dissolved. So there's no change to that. But of course, the 5 facts have disappeared, replaced by what one might loosely call a sort of self-certification regime, whereby the parties themselves inform the court that the marriage has broken down, and the court has to take that at face value. It's a subtle but important step, because if you think about it, it moves the power to end a marriage, the power to define that a marriage is at an end, from the state, from the courts, to the hands of the individuals who are in that marriage. And that's an important principle that lies behind the new regime. Well, those are the principles. Subsections 4 and 5 of the new Section 1 set out the framework. And if we read this from the top, 4A, a divorce order is in the first instance a conditional order. Pause, let's drop our eye down to subsection 5. The court may not make a conditional order unless, in the case of an application that's to proceed as an application by one party to the marriage only, that party has confirmed to the court they wish the application to continue. Or in the case of an application that's to proceed as an application by both parties to the marriage, those parties have confirmed to the court that they wish the application to continue, and a party may not give confirmation for the purposes of this subsection before the end of the period of 20 weeks from the start of the proceedings. So we can see some changes to labels, to the namings. No longer petitions, this is an application. A conditional order replaces the term decree nisi. Final order replaces the term decree absolute. And that first stage from the application to your conditional order, a period of no less than 20 weeks. Back up to the top of the page, 4B, a divorce order may not be made final before the end of the period of 6 weeks from the making of the conditional order. Obviously a feature that's relatively familiar to us with nisi and absolute. The overall period then, by process of maths, is 26 weeks. And some of those who've kindly asked questions in advance of today's meeting have observed that arguably the timescale takes us to a place longer than it does under the existing timescale. And that's designed to give the parties an opportunity to cool down and reflect on whether they want the divorce. Statutory instrument can amend those legs, either leg 1 or leg 2, but at no stage can any amendment reduce the overall period from 26 weeks. Furthermore, the court has the power to shorten the timescale. 1 subsection 8 provides that in a particular case, the court dealing with an application for a divorce may shorten the statutory timeframe. Now, there's no further help with the circumstances in which that may be appropriate, or indeed the criteria that you look at. Poonam, I know, suggests health, and one can see that that may well be a good reason for shortening the statutory timeframe. And importantly, there's a mechanism under Section 110 whereby where two parties initially apply for a divorce, one of them falls away, decides they don't want one anymore, they can't derail the process because ultimately the remaining party can continue to progress the application. And that mechanism is implemented by a new FPR 7.93. There are some similar amendments to other forms of dissolving relationships and civil partnerships. I'm not going to go into those in detail in this talk because we don't have the time. But in short, where back in under the original regime, you have to prove one of 4 facts or 5 facts. That, of course, like with the divorce orders, has fallen away, and we're now going to be introduced to a similar self-certification regime, whereby the parties certify the relevant statutory test for them to allow them to have a dissolution of a civil partnership or judicial separation. There are some amendments to applications for nullity on the basis that a marriage is void or voidable. No substantive changes to the rules, but there are changes to the timetable and to the nomenclature, the labels attached to what was a decree of nullity is now a nullity of marriage order. And I put out on the screen there the relevant schedule to look to in the event that you need to look at that. You may recall that sections 2 to 10 of the existing MCA have a sequence of what one might call supplementary, ancillary sections that support the existing framework based on 5 facts and breakdown. Just as the route has gone, on the whole, the branch falls with it. And so a number of those provisions fall away. And again, I think we don't have time today to deal with all of the amendments. You can see that the old or the existing section 2 of the MCA, the title is up there, that's supplemental provisions to the facts raising presumption of breakdown. Well, of course, facts are now gone. So section 2 is now omitted. So is section 5, that's refusing a 5-year decree based on financial hardship. But some of the stayers are on screen. Section 3, there shall still be no right to apply for a divorce order within a year of the marriage taking place. And subsection 6 remains that the legal representative of the applicant, petitioner of course under the existing language, shall certify that there have been discussions about possible reconciliation. That too remains within the regime. And then you may recall that under section 10, there is a provision which pertains to separation fact petitions, 2 years plus consent or 5 years, designed to ensure that what one might call economically vulnerable respondents have an opportunity to apply for financial remedy. This is a criterion, a rule that's now been extended across the piece to all applications for financial order. And we have a new section 10, 2 and 3, which I'm just going to read. Where a conditional order for divorce has been made and the respondent has applied for consideration of their financial position, a court cannot make an order final until it's satisfied that either no financial provision is required for the respondent, or if it is, the applicant is making appropriate provision. And the court is required to look at all the circumstances, including a list under section 10.3a, financial circumstances of the parties, ages and so forth. And so we can see there, the court has widened that provision to all divorces, ensuring that as the parties move forward from their separation, that adequate financial provision is made for respondents. Well, with the substantive law comes procedural amendments to the FPR, principally FPR 6 and 7. I've set up on the slide there the statutory instrument that gives rise to those amendments, and Poonam will be talking in more detail about them, I'm sure, in a minute. So too, the HMCTS is introducing a new online service for applying for divorces available, and that will be available from the 6th of April. The old service, that's the existing one, will be unavailable from the 31st of March. This has been relatively well publicised, so you're probably aware of it. But there's obviously a risk there. Saved applications need to be uploaded by 4 p.m. on the 31st. And there's a few days, isn't there, between the end of the old regime and the beginning of the new. Poonam, I think, will be explaining to us that provision has been made for emergency procedures in the intervening days. But there is a caveat to be noticed about that window between the two dates. What are the amendments to the rules? Well, FPR 6 is you'll remember, the part that deals with service of applications and documents. It's not surprising that there have been some consequential amendments to take account of the new regime, particularly in relation to making applications. I draw your attention to 6.7a, the bottom of the bullet points, which now enables email service of the application on the respondent, either by the court or by the applicant. But the really big change has been to a wholly new Part 7. Part 7, of course, we remind ourselves, is the part that deals with currently divorce petitions, nisi, absolute, and so forth. That's been removed and replaced with a new Part 7, which appears in its totality in the statutory instrument. It's relatively easy to navigate. It's divided into chapters, taking you through in chronological order the various steps of the process. And of course, chapter 2 is starting proceedings. Poonam, I know, will pick up on a number of these points, but I'm going to give you just an overview of the regime to get her started, so to speak. So under chapter 2, starting proceedings, a person may not make more than one application for a divorce order unless either the first application has been concluded by dismissal or determination, or the court gives permission. We'll see this is part of a number of provisions which is designed to sort of clear out the cupboard so the court is not faced with a number of competing applications or successive applications from one party. A respondent to an application has 14 days, I think it's 7 days, wasn't it, under the old existing rules, 14 days to file an acknowledgement and a further 21 days to file an answer if the claim is disputed. Interesting that the terminologies have remained. We've still got acknowledgement and answer. And at that stage, arguably as it does under the current regime, the sort of railway line divides. And we then have two class of case, two tracks. If the application is not defended, it's a standard case. If it's defended, it's a disputed case. And not surprisingly, we see from the slide on screen that the definition of disputed cases, of course, has shrunk. No longer defending on the facts, or indeed even asking the court to decide irretrievable breakdown because it's self-certified. Dispute cases are confined to where the validity of the subsistence of the marriage is disputed. There's a jurisdictional issue, or the respondent has already filed an application for a divorce order which hasn't been disposed of. If it's not one of those, it's a standard case, in which case Chapter 3 applies. And an applicant can apply for a conditional order then, no less than 20 weeks after the application for a divorce order is made, provided there's been no signal of intention to defend through the acknowledgement of service and an answer process. Applications, we remember, can be allowed by either or both applicants. So it allows for, as I said, the fall away of one of the original applicants, and the remaining applicant can go it alone. And the court will then take the application and check that there is an entitlement. If there is an entitlement to a conditional order, the court will direct that the application is listed before a judge at the next available date. A very similar ring, you may think, to the certificate of entitlement process under the existing regime. And then if not, the court lists for a case management hearing. If it's a disputed case, well, there's a different track. We've defined the limited constraints of what can be disputed. Similarly, cross applications are limited. They're limited to circumstances where either the original application has been dismissed or the respondent's own application seeks different relief from the original. Seems to me probably really meaning additional relief, additional financial relief, where again our potentially vulnerable respondent sees that not much financial relief has been sought by the applicant and that they're entitled to bring their own application, or the court gives permission. And then there are detailed provisions, which I've set out there on the slide, for steps to a trial of the dispute under 7.13 to 17. Either which way, standard or disputed, the courts find themselves obtaining their conditional order. What happens then? Well, either or both of the applicants can apply to make that conditional order into a final order. A final order can be made no less than 6 weeks after a conditional order. And FPR 7.19 subrule 4 requires the court to make a final order, except in a set of prescribed circumstances. The majority of those you might define as compliance with the procedural requirements. The parties, court must be satisfied, the courts haven't reconciled and applied for rescission. There is a mechanism for doing exactly that, applying to put the brakes on the whole process by an application for rescission. The court looks to make sure there's been no appeal pending in relation to the making of the conditional order. No party has applied to prevent the conditional order being made into a final order, essentially compliance with the steps. But in addition, it has to look a bit wider. It has to look at ensure that the parties cooperated where relevant into the dissolution of religious marriages, in particular, of course, the Jewish get. And it must also ensure that where a respondent has applied for financial relief, that that application has been disposed of satisfactorily. We're back to our section 10(2) of the new regime. The court must check if an application has been made, then is it satisfied that either the applicant doesn't need to make financial provision for the respondent, or if the applicant does need to make financial provision, then that financial provision has been made by the applicant for the respondent in terms that are reasonable and fair, or the best that can be made in the circumstances. I suppose that new section 10(2), widening the separation criteria as it does, demonstrates that the purpose of this new regime really is to look forward in these parties' lives, not to look backwards into the reasons for the breakdown of the marriage. I'm going to hand over now to Poonam to fill in some of the blanks about the new procedure rules, but perhaps just leave you with the sentiments of the former Justice Secretary, Robert Buckland, as he navigated the bill through the House of Parliament. The institution of marriage, he said, will always be vitally important, but we must never allow a situation where our laws exacerbate conflict and harm a child's upbringing by sparing individuals the need to play the blame game. We're stripping out the needless antagonism this creates so families can better move on with their lives. I'm confident it's a sentiment with which we probably all agree. Poonam, over to you.
Thank you very much, Hamish. So for my portion of this talk, I will be talking about some of the overarching themes underpinning the Divorce, Dissolution and Separation Act 2020, or DDSA, which, as you all know, comes into effect on the 6th of April this year. So I will be speaking about that for the next 10 to 15 minutes. And in my portion of this talk, I'm going to focus on 6 themes or 6 points with particular headings. And there may be some overlap in terms of what Hamish has already talked about. So first, I'm going to talk about the sea change. The new legislation is going to lead to the biggest change in the divorce landscape in 50 years, with the removal of the need to prove conduct and the parties seeking to blame each other for the breakdown of the marriage. So gone is the need to prove facts, for example, behaviour, adultery, desertion. The reason for the divorce now will be that the marriage has irretrievably broken down and no further evidence will be needed beyond this statement. The concept of the defended divorce has gone. The only challenge will relate to jurisdiction, validity of the marriage or civil partnership, fraud, and procedural compliance. In terms of principles, the overarching aim is to reduce conflict between parties who want a divorce, dissolution, or separation. There has long been a recognition over the years of the devastating effect that acrimonious divorce can have, not only on the parties themselves, but also on any children of the family who may be caught in the middle of the warring adults. And the conflict can then go on and feed into other issues such as finances or child arrangements. So hand in hand with the aim of reducing conflict is the objective of encouraging cooperation, agreement, and amicable resolution between the parties. It's hoped that the new approach will remove a lot of the acrimony, the recriminations following separation, and encourage the couples to mediate, to work together collaboratively to settle their finances and their children arrangements, and mediation is encouraged. It is also hoped that in working collaboratively towards a divorce, a dissolution or separation at the outset, that will enable a cultural shift towards couples being able to cooperate with each other at all stages of the process. My second point relates to language. So a key feature of the DDSA is the change in language in the Act, with the decree nisi becoming the conditional order and decree absolute becomes the final order. So it's the use of plain English rather than the old legal terminology. Defended cases become disputed cases. Petition, petitioner becomes application and applicant. The language in the Act has been modernised. My third point that I move on to in terms of themes is this theme of having a joint or a sole application. The changes enable a joint or sole application for divorce, civil partnership, and judicial separation. In a joint application, the parties will come to be known as applicant 1 and applicant 2. Joint applications are encouraged, but it will not be appropriate in certain circumstances. So, for example, if you have a case where domestic abuse is an issue, well then in that case, a sole application is available. There is a possibility and an ability to change from a joint application to a sole application, and that can be done at the conditional and final order stages. So if at some point during a joint application there is a falling out between the parties, then that application can be converted to a sole application. In cases that are disputed, they would need to be listed for a case management within 6 weeks. A litigant in person or a solicitor acting on behalf of the applicant can make the application. And there is the ability to make a digital and or a paper application, which is inclusive because that will cater for those individuals who are litigants in person, who may not have internet access. An application can be made for a divorce and a Form A can be issued at the same time, because these are two separate applications and they will proceed separately. The parties may wish to apply for a financial remedies consent order, but they can do that once there is a conditional order in place. Now, in a situation where an application for divorce has been made, but the respondent, the applicant is not then progressing to a final order, a respondent as well as the applicant can apply for a final order after the conditional order has been granted, but they must wait for an extra 3 months after the 6-week period has expired, and they can make an application. So if you look at section 9.2 of the Matrimonial Causes Act 1973 for that reference. I move on to my fourth point, which relates to timescales. And the timescales have changed. So a respondent to the application has 14 instead of the 7 days to respond, which it's considered is a more reasonable time frame for someone to look at and take stock of the application and then respond. The minimum 20 weeks period from the date of the issue of the application until the conditional order can be applied for. That is to allow the parties time to reflect, consider the decision. So in effect, it's a cooling off period. If the parties are having second thoughts, if they are contemplating a reconciliation, then they can inform the court accordingly. But during that time also, it does enable the parties to take stock and think about other matters such as their finances, the arrangements for any children, to be able to take legal advice or relationship counselling and other such support. Now, in special circumstances, it could be possible to fast track the 20 weeks timescale. For example, if there's a specific health issue, but this issue would have to be considered by the court following an application being made. I move on to the fifth theme that my talk relates to, and that's costs. So any party can be heard on the issue of costs. The general approach of the group that was working on the DDSA was that costs discretion should be retained, including the clean sheet cost rules, and that there should be a high benchmark needed for cost orders to be made. So from a policy perspective, I'm going to quote from the Family Procedure Rules Committee minutes for the 10th of May 2021, paragraph 7.4. And these minutes are a matter of public record. They are on the gov.uk website, so anyone can access them. Now at paragraph 7.4, Ministry of Justice Policy said that, as previously discussed at the committee's April meeting, both the working group and the committee was of the view that clear guidance, hoped to be the President's guidance, should set out the high benchmark for cost orders being made under the new DDSA landscape. In the context of it being agreed that current clean sheet rules on costs should be retained. The Family Procedure Rule Committee minutes for the 14th of June 2021 at paragraph 7.4 record, the draft amendments to rules 7.10 and 7.32 had the effect that any application for costs should not be made in the principal application. So instead, such an application in a disputed case should be made at the hearing of the application, or in a standard case by application notice under Part 18. So the purpose of these changes is to discourage speculative applications for costs being made at the outset of proceedings, as this could undermine the policy intention to reduce conflict in the legal process of divorce. So in a standard case, cost orders should only be made on an exceptional basis, such as where there has been litigation misconduct, including, for example, the deliberate evasion of service by a respondent party. So that's the reference to those minutes. So to recap on that, in circumstances when a respondent doesn't reply to the application or there is non-engagement, then the applicant has to show service of the application and can apply for deemed service. My final point, 6, relates to the next steps and forms. So as most of the delegates here are aware, the divorce reforms will lead to changes in the digital divorce and financial remedy portals. Now, the Ministry of Justice digital team are continuing to work to build the online platform for online applications. So it is useful to check the gov.uk website ahead of the launch on the 6th of April to look to see any updated guidance. There will be court forms that must be used from the 6th of April onwards, and the revised Part 6, that deals with service, and Part 7, which deals with procedure for applications in matrimonial and civil partnership proceedings of the family procedure rules, and the amendments to the practice directions which are consequential to the DDSA, they will apply. So this is probably a topic for part 2 of this talk on another occasion. Now, further information can be found at the legislation.gov.uk website, and I will ensure that a reference to that website, a link is included with the notes from this part of my talk. Some individuals have asked, well, what will happen during the period of the 31st of March and between that date and then the 6th of April when the new law comes into effect? So with urgent applications that have to be considered after the 31st of March, but before the 6th of April, they will continue to be accepted and issued where possible, if they're received by post or email. So if you submit your urgent application by email, you would be asked to use the following email address. It's online dfrjurisdiction@justice.gov.uk. And again, I will ensure that that email address is contained within my notes for the delegates at the end of this talk. But you've got to note that that email address will be unmonitored after 4 p.m. on the 5th of April 2022, so that by the following day, that's when the 6th of April new regime change comes into effect. So essentially, this has been an overview on my part of what is underlying some of those changes and themes and principles behind the DDSA. Having come to the end of my portion, I'm going to now pass everybody back to Hamish Dunlop to continue with the question and answer section. Thank you.
Thanks, Poonam. We've had a lot of questions, and so I'm going to try and make my way through a few of them. One question we had in advance of the seminar was a rather broader question of philosophy about the Matrimonial Causes Act, section 25(2)(g). That's, of course, the provision that requires the court to look at conduct when deciding financial orders. And in circumstances where now, arguably, the behaviour petition has gone, is there still a place for an amendment to section 25(2)(g) so that conduct can no longer be relied upon in financial remedy proceedings? I suspect that the answer to that is there is no case for removing section 25(2)(g), the conduct limb under the MCA. There's going to still be a legitimate place for it, it seems to me, under the section 25 criteria, particularly financial conduct. Certainly the relevance of financial conduct isn't, of course, in financial remedy cases based on a kind of moral principle, which arguably section 1(2)(a) and (b) of the MCA are. The position over non-financial conduct is a bit more nuanced, but it seems to me in the rare cases that it exists, there are often perfectly good financial reasons for concluding that financial conduct, for concluding that conduct has relevance to the outcome of a financial remedy order. Some rather more, some questions based really on the working of the rules, were asked, will the old law continue to apply to petitions issued before the 5th of April 2022? I think that's a sufficiently important question, though, although we've covered it in the talk, I'm going to make it absolutely plain. The existing divorce petitions will continue, and they'll continue up to the end of March, when we know on 31st of March the window closes at 4 p.m. And if you've got any pending petitions, get them uploaded by then. And once those are uploaded, then the old law will continue. Another question, again, I hope covered during the course of the talk, but sufficiently important to give profile to it. What if one party applies for the divorce and the other party chooses not to progress it? Well, of course, we've seen that at various stages there is the opportunity for where a joint application is made for a divorce order, one of the parties to no longer pursue, fall away, so to speak, and the rules are specifically prescribed that in those circumstances the remaining party can continue to prosecute their application for a divorce order, and the fact that the other party chooses to fall away and not to progress it can't derail the process. And then one question, I'm going to hand over in a minute to Poonam to sweep up some others, but one question which has been asked in a number of different ways is this: if you act for both applicants in a joint application for divorce, how does that work for financial proceedings? Can I still only act for one applicant for finances? Well, of course, it goes without saying that this engages the question about conflict, and questions of conflict are largely, of course, for individual practitioners. It strikes me that where a solicitor chooses to represent both parties to a joint application, they need to think very carefully about how that may end up, and in particular, as the question infers, how it will end up with financial proceedings. Just because a couple are content to join hands for an application for a divorce order, I think we'll recognise, does not mean that they're going to be agreeable to approaching the court for a financial remedy order on agreed terms. And I think personally, I would be quite reluctant to act for both applicants on a joint application. Although I do recognise that I don't think there's anything that specifically prevents that, but it would be something that you'd need to approach fairly carefully. Shall I pause and give, Poonam, I'll give you a chance to perhaps address some of the questions that have been asked. Over to you.
Yes, thank you, Hamish. I've got some similar questions here. Somebody's asked, what would a barrister with public access authority to conduct litigation who is representing and conducting the divorce for an applicant be able to lodge the relevant paperwork, please? Again, this is the answer to this question, I would suggest, means really looking at the BSB conduct and regulations and checking with the regulator whether that's permissible, and also the guidance that will come out in due course around the practical steps that need to be taken. And in a similar vein, we had a question in advance: how can we as solicitors submit joint applications acting for both parties? I see that this will be an option, but not on the digital system, only on paper. Surely we cannot act for both, as there would be a conflict of interest. Well, my response would be that any guidance from the SRA should be followed here. Joint applications for divorce and dissolution can be made online or on the papers. They can be made by the solicitor or two solicitors instructed on behalf of each of the parts, so one of the parties each having their own solicitor. Now, where either or both joint applicants have instructed a solicitor, the application must be made by the solicitor through the digital service, unless there's only one solicitor acting for both the applicants. So in that instance, the paper form must be used, but watch this space. Joint applications will have the terminology so that the applicants will be known as applicant 1 and applicant 2. But what I would say is note all the different permutations here. So there could be one solicitor for the 2 individuals, for the couple or the joint applicants, or we could have each applicant having their own solicitor in a joint application, or one applicant may have a solicitor and the other applicant could be a litigant in person. Now, if the applicants have started with a joint application, but then the situation deteriorates, they can switch from the joint application to the sole application at the conditional and final order stage. And if that happens, then if there's an application for a final order being made, it must be made on notice. So if one party's got a solicitor acting, then the other party needs to be notified and they can decide what they want to do. There was also a question around claiming costs under the new procedure if no agreement had been reached on costs. So with the application for costs of an undisputed, so a standard divorce or dissolution, that would need to be made by a separate application using form D11. That's the general standard application form. And that application would go before a judge and then be decided by a judge. And Hamish had already referred earlier on to rules 7.10 and 7.32, which set out some provisions in terms of costs. There will be guidance, as I understand it, in due course around completing the N260, dealing with the costs that are incurred. I think at this stage, perhaps if I pass back to Hamish just to see if there are any other questions that he may wish to follow up at this stage. Thank you.
Well, there are a great number, but and some of them, Poonam, are focusing on the new section 10, 2 and 3 of the 1973 Act. That's this provision that if a respondent to the divorce application makes an application for financial support, then the court can't make a conditional order final until it's resolved that application. By way of example, one of the questions is, do section 10.2 and 10.3 suggest that the applicant might not need financial support? It suggests that the respondent is always the weaker party. I'm just going to see if I can pick up another one because I want to talk about the point generally. If either party is able to apply for a financial order, if you're dealing with complex finances, do you have to submit an application to prevent an FO being made to protect the pension position? As I read the rules, the new rules, in particular how they interpolate, how they interact with the application for financial remedy, the two provisions are not somehow inherently tied together. As you were demonstrating in your talk, of course, it's perfectly open for an applicant for a divorce order to start the process of their application, at the same time file an application for financial remedy. And so actually the parties could conduct the application for a divorce order without any specific reference to section 10.2 and section 10.3. It is only that under the application for a divorce order, there appears to be this opportunity within the divorce order application process for the respondent to say, I wish the court to look specifically at my financial circumstances before the financial order is made. And under that trigger, the court then cannot make the final order until it's satisfied that the financial remedy aspect has been dealt with. And as I read it, that will simply mean that the court will then say, well, before I can make this conditional order final, I need to ensure that the parties have gone through the appropriate for me process, they've exchanged financial information, and the parties have either reached a concluded agreement under the eyes of the court, or alternatively, the Form A has been issued and the court has resolved the issue through a financial remedy process. I think the provision under section 10, 2 and 3 is really designed just to ensure that there is a safeguard for respondents who might be financially vulnerable. I'm going to cheekily try and use the last couple of minutes just to turn back to our slideshow we had at the start. I did, I think, at least post one slide on screen before I talked. And am I right about that, Poonam? We did have the image on screen of the actors. Great. Well, I tell you what, I'm going to try and share that again with everybody. I'm just going to pop it back onto the screen. I'm assuming that participants can now see it because my computer tells me that they can. And for those of you who were interested, let me just go round like a sort of clock face. Top left, the images we see in the screen there are images from the recent film Marriage Story, starring Laura Dern and Scarlett Johansson. To their right, and those of us who are slightly longer in the tooth may recognize an image from The War of the Roses, a film starring Kathleen Turner on the left, of course, and Michael Douglas on the right. Bottom right, even longer in the tooth, if I may respectfully say, a TV film starring, of course, Richard Burton and Elizabeth Taylor, probably lesser known as a film called Divorce His, Divorce Hers. And then finally, arguably the kind of most famous divorce film of all time, Dustin Hoffman and Meryl Streep, starring in Kramer versus Kramer. So well done to anyone who got even 70% of the answers to that. Can I hand over to you, Poonam, just to sign off on the lecture?
Yes, thank you. I want to say thank you to everybody for attending this seminar and for engaging with us. We've got to 62 questions already, so it's phenomenal. Thank you so much. The next webinar, it's going to be on the 28th of April of this year at 11 o'clock. And the invitations for that will be sent out by email, but also our contacts may pre-register for that. I think there's also a link in the chat box, and we can follow up, obviously, with anything and queries that people have afterwards. So thank you very much, and goodbye.